Today we're going to talk about civil rights and civil liberties. These are the protections that are provided to individuals against the government. Federal, state, individual. These are the three entities that are sovereign. They're where the power lies in the system and where power comes from. Federalism is the shared powers of the federal or national government and the states. But we always need to remember it's the individuals where power resides ultimately. And that power is granted to a government. This is a basic concept of our government, that the people grant the government the power over them to collectively govern. And so the problem is, how do you prevent that government from being too strong? The central debate at the Constitutional Convention and its aftermath was how to create a government strong enough but not too strong. Strong enough to govern but not too strong to threaten individual liberties. Now, James Madison, who's considered the father of the Constitution, was the chief writer and architect of the Constitution, didn't think that additional protections were necessary. He thought that the checks and balances and the individual protections in the Constitution between the three branches were sufficient. But others didn't think that way. They felt that the Constitution was lacking statements of protecting the rights of individuals. That's what was called the Bill of Rights. Now, the Bill of Rights are the first 10 amendments to the Constitution. James Madison, in addition to being an architect of the Constitution and later president, was a member of the first Congress. And as a member of the first Congress, he introduced these amendments to the Constitution as he pledged to the delegates and to the other drafters of the Constitution during the ratification. He said, well, we'll correct this. We'll correct this right away. We'll correct this by drafting a Bill of Rights and adding those as the first 10 amendments. So what they did was to try to define the balance of power between the national and state governments and between the individuals and the national government. So the First Amendment is probably the most well-known. It's the most reaching. It grants the freedom of speech. It grants the freedom of the press. It grants the right to practice your own religion and prohibits the state from establishing a religion. It grants the right to peacefully assemble, meaning to have demonstrations, and to petition your government for redress. So these are all rights to give to the individual a free expression: religion, speech, press, assembly. The other amendments primarily grant individual rights. The right to bear arms is an important right, been debated for a long time. Some people thought there was some ambiguity, that it really referred not to individuals in their homes, but to militia. But the Supreme Court recently ruled that it did involve individuals and established for the first time really no ambiguity that the Second Amendment meant the right to bear arms. It remains controversial today simply because of the violence and the people feeling that government wants to threaten their right to have guns. And so you can see why this right, without this, it might be a different story. The securing your own homes from unreasonable search and seizures. So that if you're stopped by the police for speeding, the question is, do they have any reason to search your car for drugs? There has to be some reasonable purpose to this, not just a suspicion or not just because they've got you there. So that is, again, the right to be secure in our homes, the right of self-incrimination, or the right not to have double jeopardy, as we often call this the O.J. Amendment, because O.J. Simpson can't be tried again for the same crime if he's been acquitted. The right to a speedy trial, the right to have a jury trial, the jury of your peers, and no excessive bail. So all these are individual grants of rights so that we feel more secure in ourselves and that the government has limitations placed upon it. There are two final amendments in the first 10, the 9th and the 10th, that are broad amendments. The 9th has said that these powers aren't the only powers. These rights are not the only rights. That individuals are granted other rights that simply aren't enumerated. That was one of the complaints and the concerns originally that said, well, if we enumerate these rights, people will think that's all you have. So the 9th Amendment said, no, that's not true. There could be other rights that aren't enumerated here. And an important one is the right to privacy. The courts have used this 9th Amendment to say that there's a right to privacy to use contraceptives. In the famous case of Roe v. Wade, the right to have an abortion. That's a woman's right to privacy. So you can see here that 9th Amendment was used to say there are other rights that are implied that are not explicit. So rights can exist that are not in these first 10. And the 10th Amendment is to say that all powers not delegated to the government are reserved to the states and to the people. This is designed to say that powers ultimately belong to the states and the people, and just because we gave these rights and power to the national government doesn't mean that all powers are granted to the national government. Conservatives love this amendment because it says that the states and the individuals are sovereign and that they have these powers. It's really hasn't had a great deal of impact. Conservatives, as we say, like the 10th Amendment because they feel that the states are closer to the people and the local governments are closer to the people and the national government has grown too strong. So the 10th Amendment gives them hope that they could have a government that's smaller at the national government and grant more powers to the states, say over education or housing or welfare that don't need to be national priorities but could be state priorities. One other amendment we have to talk about is the 14th Amendment. The 14th Amendment and what's later called the Incorporation Doctrine says that the Bill of Rights don't just belong to the national government to protect individuals from the national government, but they also apply to the states and to limit the states. So that's where you see the famous language that starts the 14th Amendment. Now, the 14th Amendment is a post-Civil War amendment to sort of ban slavery and ban practices of the states. So when it says, no state shall make or enforce any law or which shall abridge the privileges or immunity of citizens of the United States. So here we are, citizens of the United States, and the state government can't restrict our freedoms any more than the national government can. Nor can it deny to any person within its jurisdiction the equal protection of the laws. This is powerful language interpreted by the courts to extend individual protections to the states. Now, it wasn't always that way. The 14th Amendment didn't have the impact initially that it has today, as the court says, well, that's what that phrase means, no state shall, and applied it to the states. And so it gave, as we'll see, a greater role now to the federal government. Remember, federal, state, individual. The federal government now protecting the rights of individuals from the states that may have been reluctant to enforce certain laws. So the impact of the 14th Amendment, those three important phrases in there, no state shall, you should provide due process of law, and provide equal protection of the law. Courts have interpreted these words to enforce civil rights, to require notice and openness when rights are threatened, that you had to have a hearing, you had to be notified of the charges against you, that you just couldn't be fired from a job without notice and the possibility of appeal. These provided expanded protections. The Equal Protection Clause was used in the famous case of Bush v. Gore, which when the Supreme Court decided the Florida case of how to count the ballots, It said that people could not be denied the equal protection of the law, that everybody's ballots had to be counted equally, or otherwise they weren't being provided the equal protection. Civil liberties have expanded. It wasn't just the first 10 amendments, then the 14th Amendment, but also the Civil Rights Act of 1964, and then later the Voting Rights Act of 1965. These were passed over Southern resistance, and it's been the enforcement of the Civil Rights Act of the federal government over the states that have strengthened civil rights. Using this 14th Amendment expansion, the no state shall deny equal protection, the courts, for example, interpreted segregated schools as not being equal, not providing equal protection to students. And therefore, that we see in the 60s, late 50s, 1960s, the federal government using military force, enforcing the rights of individuals who wanted to attend a school, say a segregated school, that the national government using the federal powers enforced by the courts to integrate those schools. So we see the national government using the 14th Amendment and the Civil Rights Act then to enforcing equal protection when the states were resisting. So those are sort of the key elements of civil liberties and civil rights provided by the first 10 amendments, the 14th Amendment, and the Civil Rights Act that gave protection to individuals against the government. So in coming weeks, we'll look at the institutions that shape our government today and the policies that